on the morning of June 2nd, 1692. In a meeting house in the small Massachusetts village, a court was convened that had no jury law, no defense counsel, and no rule against testimony that no living person could see. Over the next 4 months, this court would examine more than 150 people for the crime of witchcraft. 19 of them would be hanged. 1 would be crushed to death under stones. At least 5 more would die in chains in unheated jails. And the central evidence against them, the evidence that sent grandmothers and farmers and a 4-year-old child to prison, was the testimony of a handful of girls who claimed they could see ghosts in the courtroom that no one else could see. This is the Salem witch trials. To understand the trials, you have to understand that Salem Village in 1692 was a community already tearing itself apart long before anyone cried witchcraft. Salem Village was a poor, anxious farming community on the inland edge of a wealthier port town. It was split by years of bitter feuds over land, over the boundary lines of farms, over who would pay the minister, and whether they wanted him at all. Families had been suing one another for a generation. Into that village came a new minister, Samuel Parris, a former merchant who had failed in business and who quarreled constantly with his own congregation over his salary and his firewood. In the winter of 1692, inside the Parris household, 2 girls began to behave in a way no one could explain. Parris's 9-year-old daughter, Betty, and his 11-year-old niece, Abigail Williams, fell into violent fits. They screamed, they contorted, they complained of being pinched and pricked by something unseen. A local doctor examined them, could find no illness, and offered the one diagnosis that a Puritan village understood completely. Pressed to name who was tormenting them, the girls named 3 women: Sarah Good, a homeless beggar; Sarah Osborne, an old woman who had scandalized the village by remarrying her servant; and Tituba, an enslaved woman in the Parris household. All 3 were people the village was already prepared to believe the worst of. The 3 accused women were brought before the local magistrates on the 1st of March, 1692. 2 of them denied everything. The 3rd did something that changed the history of the colony. Tituba, facing a hostile room and the near certain prospect of a beating, confessed. And she did not simply confess. She performed. She told the magistrates a vivid, detailed story of a tall man from Boston, of a book that witches signed in blood, of creatures that flew, of a great conspiracy of witches in their very own village. It was, almost certainly, exactly what she had learned the magistrates wanted to hear. Confession spared her life. The court did not hang those who confessed and named others. But her confession did something catastrophic. It told the entire village that the witches were not 3. They were many. And they were hidden. Now, the village had a problem with no bottom to it. If the witches were hidden, then anyone could be one. And the only people who could identify them were the afflicted girls, whose number over the following weeks grew. More girls began to have fits. More girls began to name names. and the names climbed the social ladder. By May of 1692, the jails of Essex County were overflowing. Dozens of accused people were chained in cells waiting for trials that legally could not happen because the Massachusetts Bay Colony, at that exact moment, had no legal government and no valid charter. In mid-May, the colony's new royal governor, William Phipps, arrived from England. He found a colony in panic and the jails full. His solution was to create, by his own order, a special court, a court of Oyer and Terminer, an Old English term meaning to hear and to determine. To run it, Phipps appointed as Chief Magistrate his Lieutenant Governor, William Stoughton. Stoughton was a Harvard-trained former minister, sharp, austere, and absolutely certain. He had no formal legal training. He had something the situation rewarded more. He did not doubt himself. And he did not doubt that the witches were real. The court convened for the first time on June 2nd, 1692. It had no defense attorneys. None were permitted. It had no presumption of innocence that resembled our own. And it made one ruling, early and quietly, that decided the fate of almost everyone who came before it. The court ruled that it would accept what was called spectral evidence. Read that ruling again, because it is the engine of the entire tragedy. If a girl in the courtroom screamed that she saw your ghost pinching her, that was evidence against you. You could not cross-examine a ghost. You could not call witnesses to where your ghost had been. The accusation and the proof were the same thing. The court's reliance on spectral evidence was tested almost at once by the case of a woman whom the entire village knew to be good. Rebecca Nurse was 71 years old. She was a full member of the church, a status not lightly given. She was the mother of 8, a grandmother many times over, frail, and so hard of hearing that she could barely follow the questions put to her. When she was first accused, 39 of her neighbors signed a petition swearing to her good character. An act of real courage in a village where defending the accused could get you accused. Her trial should have been the moment the court found its conscience. Instead, it became the moment it lost it. During her examination, the afflicted girls in the courtroom fell into fits whenever she moved. When she lifted her hands, they screamed and lifted theirs. When she leaned her head, they leaned and shrieked that her shape was breaking their necks. The jury, remarkably, first returned a verdict of not guilty. For one moment, reason held. And then the afflicted girls erupted in a storm of fresh fits in the courtroom. And Chief Magistrate Stoughton sent the jury back. Rebecca Nurse, deaf, exhausted, 71, had said one of us, meaning a fellow prisoner. The court chose to hear it as an admission of conspiracy. The jury reversed itself. Rebecca Nurse was condemned to hang. The trials revealed a cruel arithmetic. Those who confessed and named others were spared. Those who insisted on their innocence were hanged. The court was, in effect, rewarding lies and punishing the truth. Two men in particular refused to play. The first was John Proctor, a prosperous tavern keeper, blunt and outspoken. Proctor had said from the beginning, loudly and to anyone listening, that the afflicted girls were frauds who deserved a whipping. For saying that out loud, John Proctor was accused, tried, and condemned. So was his pregnant wife. His own servant girl, one of the afflicted, testified against the household that fed her. The second man was Giles Corey. He was 80 years old, a tough, stubborn, quarrelsome farmer who had himself earlier foolishly given testimony that helped accuse his own wife. When the court turned on him, Giles Corey understood the machine better than the judges did. Corey knew that if he stood trial and was convicted as a witch, the law could seize his entire estate, leaving his sons-in-law with nothing. But under English law, a trial could not even begin until the accused entered a plea, guilty or not guilty. So Giles Corey refused to enter one. He stood mute. The court's response was an ancient and brutal procedure called peine forte et dure, strong and hard punishment. A board was laid on the old man's chest in an open field beside the jail, and stones were piled onto the board, one after another, to force him to plead. For 2 days, Giles Corey lay under the stones. Each time he was asked to plead, witnesses recorded that the old man said only 2 words. Giles Corey was pressed to death on September 19th, 1692. He never entered a plea. He never stood trial. His estate passed to his family exactly as he intended. He remains the only person in American history ever executed by pressing. To understand how the court could believe what it believed, you have to sit in that meeting house and watch what actually happened when an accused person was examined. The afflicted girls did not sit quietly and give statements. They performed the torment in real time in front of the magistrates, in front of the whole village. When an accused person spoke, the girls would scream, writhe, go rigid, fall to the floor, and cry out that the accused person's invisible shape was biting them, choking them, holding out a spectral book for them to sign. Here is the examination of a typical accused woman. Listen to how the court treats the accusation and the fit as a single, unanswerable fact. And every head in the meeting house turned to the empty beam. And there was the trap, closing. By the court's own ruling, the devil could not wear an innocent person's shape. So to admit her shape was being used was, by the court's logic, to admit her guilt. There was no answer a prisoner could give that the court would accept as innocence. One minister, watching session after session, began to feel the ground move under him. John Hale had supported the trials from the start. He had urged them on, but Hale was watching the accusations climb toward respected church members, toward the wealthy, and finally, toward his own wife. Through the summer of 1692, the court of Oyer and Terminer worked with terrible efficiency. On June 10th, Bridget Bishop was hanged, the first. On July 19th, 5 women, including Rebecca Nurse, were hanged together on the rise west of the village. At the foot of the gallows, Rebecca Nurse, 71 years old, was reported by witnesses to have prayed not for herself, but for the souls of the people who had condemned her. On August 19th, 5 more were hanged, including John Proctor. On September 19th, Giles Corey was pressed. On September 22nd, 8 more people were hanged at once. The last the court would ever execute. 19 hanged. 1 pressed to death. At least 5 dead in jail. And then, in October 1692, it stopped, almost as suddenly as it began. The afflicted girls had grown too ambitious. They began naming the well-connected and the powerful. They accused the wife of Governor Phipps himself. At the same time, the colony's most respected ministers, led by Increase Mather, published a warning that struck at the court's foundation. On October 29th, 1692, Governor Phipps dissolved the court of Oyer and Terminer. He forbade any further arrests. When the cases were finally retried in a new court the following year, a court that refused to admit spectral evidence, the results were almost the mirror image. Of 52 remaining defendants, 49 were found not guilty. The Salem witch trials left a colony that did not know what to do with its own shame. 5 years later, in 1697, the Massachusetts legislature ordered a colony-wide day of fasting and repentance for the trials. On that day, one of the trial judges, Samuel Sewell, stood up in his Boston church and had the minister read aloud a statement in which he accepted the blame and the shame of the Salem court. 12 of the trial jurors signed a public statement of their own. They wrote that they had been deceived, that they could not now understand what they had done, and they begged forgiveness from the living and from the families of the dead. Reverend John Hale wrote an entire book, a careful, grieving account of the trials he had once urged on. William Stoughton, the Chief Magistrate, the man who had sent the jury back to condemn Rebecca Nurse, never expressed a word of doubt. He went on to become governor of Massachusetts. A county is named after him to this day. In 1711, the colony reversed the convictions of many of the dead and paid small sums of compensation to their families. But it was not until the year 2001, more than 3 centuries later, that the last 5 names, including Bridget Bishop's, were formally cleared by the state of Massachusetts. The Salem witch trials are remembered as a story about superstition. But the people of Salem were not unusually stupid, and they were not unusually cruel. What they had was a court, a real court with real judges that agreed to accept one specific kind of evidence, an accusation that could not be seen, could not be tested, and could not be answered. And once a court will do that, the verdicts write themselves. If you want to come with us to other courtrooms, to the dock at Nuremberg, to the trial of Joan of Arc, to the day a king of England was tried by his own subjects, subscribe to the highest court. Because the most dangerous thing a court can ever do is decide that it no longer needs to be convinced.